and calling in,
Oh,
so
that's just
I think that's what's being worked on right now. I would like. Everybody to receive the agenda. I would like to entertain a motion to approve the agenda.
I move we approve the agenda.
I'll second.
All in favor, say aye.
Aye.
Thank you. Agenda approved. Approval of the minutes of our last meeting, February 9th. We all had those minutes before the meeting. I'd like to entertain a motion to approve the minutes.
I move the minutes be approved as presented for February 9.
All in favor, say aye.
Aye.
Thank you. Minutes approved. We have on the agenda public comments. Anybody signed up or wants to?
No, we've received no emails and there's no one here unless one of them was going to speak.
Oh, I thought Roger wanted to speak. Okay, next is new business. We have a new member, Eugene Edwards, and our fearless town clerk will administer the oath.
Understand?
Sure. What we're not going to do is actually touch the Bible. I'm just going to have you raise your hand.
Proximity thing?
Yes, because of the pandemic.
Okay.
Okay. Okay. So I state your name.
I state your name. I, Eugene Edwards.
But you're doing fine.
You go fit right
Do
in.
solemnly and sincerely swear that I will support the Constitution of the United States.
Do solemnly and sincerely swear that I will support the Constitution of the United States.
That I will be faithful and bear true allegiance
That I will be faithful and bear true allegiance
to the state of North Carolina
to the state of North Carolina
and to the constitutional powers and authorities which are or may be. And to the constitutional powers and authorities
and to the constitutional powers and authorities
which are or may be established
or may be established
for the government thereof.
for the government thereof.
And that I will endeavor to support,
And that I will endeavor to support,
maintain, and defend
maintain, and defend the Constitution of the United States.
not inconsistent with the Constitution of the United States,
Not inconsistent with the Constitution of the United States.
to the best of my knowledge and ability.
To the best of my knowledge and ability. So help me God.
I, state your name,
I, Eugene Edwards,
do further solemnly swear
further solemnly swear
that I will execute the office
that I will execute the office
of Board Adjustment
of Board of Adjustment Member
for the town of Village River
for the town of Village River, North Carolina,
without prejudice,
without prejudice,
favor, affection, or partiality,
favor, affection, or partiality,
to the best of my skill and ability.
to the best of my skill and ability.
So help me God.
So help me God.
Now we just get to the assignment. You have a hand up, it's a lot. I know, it's a lot. But once you sign it, you are official.
That's scary too.
A little bit. Thank you.
Well, we welcome you to the Board of Adjustment.
Thank you.
Next on the agenda is a training, and that is led by our town manager and town attorney.
Thank you, Mr. Chairman. Sharon, are you able to hear us and speak to us?
No, it's the same.
It looks like you're unmuted. Well, while she's getting set up and hopefully will be joining us in just a moment, we thought we would take this evening as an opportunity to sort of refresh the Board of Adjustment's role and We do have a case coming up in May, and we just want to make sure that everyone's comfortable with the procedures for quasi-judicial evidentiary hearings. Once Sharon gets on the line, she'll be able to give us a little bit more guidance as to what may or may not be different about the hearing coming up in May. And just for a little bit of background.
Daniel, I'm here. Can y'all not hear me?
There we are. Now we can.
Okay.
Okay, so again, there was a hearing in September. This board approved the application, and then it was challenged by some neighbors who retained legal counsel. It went up to Superior Court, and there was a consent order put together, and I believe that has been signed by the attorneys involved. And the case is being intended to be remanded back to the Board of Adjustment for a de novo hearing in May. Sharon, do you have any more background information you'd like to share with the board about the status of the case?
Daniel, I'm having a hard time with my connection, so I'm going to get my iPad, and that seems to connect better. But the order has been presented to the judge. Yes, all the attorneys have signed it, and so we're waiting to have it entered.
Okay, that's good news. I'll let Sharon get into the legal component of that in just a moment when she gets set up. But basically, all parties have agreed that the case needs to be heard again, and they will present evidence at that hearing. The application has not changed, and it won't change.
And other than that, it is a hearing as if you all have never heard it before. So it'll just be like very much a regular quasi judicial meeting for you, hearing for you.
So Sharon, just a dumb question from my side. So basically we have to forget what we said, thought, or heard. She's off right now.
Maybe she went to get her iPad.
While we're waiting on our attorneys to come reconnect, for Mr. Edwards' information, because this is all new to you. This board hears requests for certain items, variances, special use permits, conditional use permits. Well, I thought there was one there. Okay, conditional use permits, and appeals from the zoning administrator. And the hearings are held in what they call quasi-judicial or evidentiary hearings. So it's almost like court, but it's not exactly like court. And we will, once that starts, you'll have a sheet that kind of gives you a procedure on how to follow, and just give you an idea of what we're doing here.
Well, it made Hendersonville Times News also. Mhm.
Sharon, can you hear us okay?
Yes.
Okay,
Can you hear me?
we can. Yep, while you were switching devices, we were just talking to Mr. Edwards about the purpose of the Board of Adjustment, the cases that it hears. And you came back on. Mr. Edwards is a new member of the board.
Daniel,
Yes,
I came out early and tested my internet connection and I had no problem, but I think that I'm freezing a lot, even on my iPad.
Do you want to call in?
Well, I may do that in a minute. Let's try for a minute because now it looks like it's resolved. Sometimes it just seems like it has to find the right path. Can you hear me now?
Oh, yeah, loud and clear. I don't know if you heard Bert's question a moment ago, but Bert, would you mind repeating that? please,
Yeah.
Sharon?
If I remember.
Is she
So
with us?
Sharon, in this new hearing, are we supposed to forget what we thought, said, read in the previous hearing? And on top of that,
No, this
there is
just
newspaper.
start completely from scratch.
Okay, so we do not have to recollect anything that we said or thought during the first hearing. We're supposed to
No.
forget.
It would actually be error for you all to consider anything from that first hearing.
Okay. Second question, there are some articles floating around in the press earlier and today again. What do we do with that information? Sharon, are you there?
I'm here. I just
Okay.
sent Sue a text and asked if I could just call because I'm sorry. They worked on our internet, told us they had it fixed, but they obviously don't.
All right, give us just a minute, Sharon. We'll get the conference phone set up for you.
Okay, I'm back with you now, but Sue says she's gonna let me connect by phone somehow.
Oh, like, it's the one in the middle. Okay, unplug that. And yes, whoever asked that, she isn't home. I remember. Starting out asking questions. I just- for a second.
I get the control box, turn it off.
And just be very careful.
Yeah, what you? It's got that icky sound.
Hey, Sharon, you want me to call your cell number? I guess we'll call her cell. That's the number, okay? Hello? Sharon? Yeah, that's Sue. Okay, we got you on speakerphone now. Okay. I'm sorry, I'll have another conversation, but that's me and Steve tomorrow. So Bert was asking about how to deal with the heard my answers or not?
We did not. If you could start over.
Okay. So this is what the court would call a de novo hearing, which means you start from scratch. And you really have to treat it as if, in all respects, you've never heard anything about it before. If one of the parties wants to introduce something on the basis that it was introduced at the last hearing, the answer just needs to be you just need to lay the foundation and introduce it as if it's never been forced before.
Okay. How are we supposed to deal with the press articles that are in newspapers right now?
Well, my preference would be kind of like if you were sitting on a jury, that you not read them. The judge, if you were sitting on a jury, the judge would have instructed you at the beginning not to read. So my strong preference would be that you guys try not to read it, and if someone tries to talk to you about it, you explain to them that it's really not fair for either side for you to have any kind of conversation like that. But as most of you probably know, you can, at the beginning of the hearing, if anybody feels like they need to put something on the record because someone has ambushed them about it, or they drive by the place, every day, they just want the parties to be aware of what their knowledge is starting. You can put that on the record.
Okay.
So obviously, those of you who sat in the last hearing would just say, I was the Board of Adjustment, and we heard this before. But, and then they may ask you, have you already made up your mind? And, how could you if you haven't heard any evidence this time yet? And I promise you'll hear, it's not different evidence, you're going to hear more evidence.
Okay. Just matter of order then, can people ask individual members of the Board of Adjustment questions that we have to answer?
If one of the members of the board has said, I live in the area and drive by there, they should be allowed to ask general questions like, has that caused you to already make your mind up? Has that created any bias on your part? But not other than that.
Okay.
I mean, in an extreme example, if somebody on the board had been quoted in the press as saying something, clearly whatever, then that would be another situation where the party could ask to be able to examine that member.
Okay, but that, speaking for myself, but I don't think anybody of the board, as we sort of got instructions not to get involved in any discussions or, interviews, I don't think anybody has, as far as I know.
No.
But and I'm just trying to think about things that have been the subject of lawsuits or, stories they tell. And one thing is that out in the community, because I know feelings are running kind of high about this, somebody may have told somebody that one of you said something. And so, one of the parties may come in saying, I heard that you said whatever. So y'all do kind of need to be prepared for that. And I'm not implying it's going to be something that actually happens. But you just need to be prepared. And that's something, if it's really, if whatever reportedly was said is really on point and indicates a bias, then they have a right to ask you if you said it. And if the answer is no, that's the end of it.
Or we can say, I do not recall.
Right.
Sharon, it's Linda now. This thought entered my mind once I knew we were rehearing the case, and I understand that the request is to be presented as it was initially presented. But what if the applicant rephrases things when they're talking to the board that don't parallel, and we'll be able to read the paperwork again, I'm presuming, on the application? I mean,
It's gonna be the same application, so yeah.
okay, and that's their script, so to speak, of what they're going to be saying to us.
So they come along with this, and I'm sure there will be a different script, but still the foundation of everything is the same application that you all have already seen.
And it, in theory, will not be expanded upon.
If they want to amend the application, you're not having a hearing.
Got it, thank you.
During this hearing, do we get access to your assistance?
So because I represented the town in the court action, and I have a conflict, makes no sense that I have a conflict, because, I mean, there is always the possibility that the town could take issue with what the board does, and that's happened in other places. So I'll be there to represent the staff on behalf of the town, and Mac McKellar, Judge McKellar, will be there to represent you all, to give you guys advice.
Okay.
I'm a little confused about that. I got no problem with it, but we are appointed by town council.
Right.
So,
But you're also supposed to be independent, and in fact are independent. I mean, you guys, you don't go ask town council how they want you to rule on things.
correct.
And so, or it's mostly lawyers that make no sense to anybody, probably not even the people who make them up. But it's because it is at this point, so usually when you all have hearings, they're really not going in, you don't have any reason to believe they're adversarial, so I can represent the board and give the board advice, but if Daniel has a question, I can also give him advice, because there's no conflict there. But the bar thinks there's a conflict now, or really the potential for a conflict between the town and the board. So the rules of ethics say that there should be separate counsel for each.
Okay, clear. What can be the, is there a potential for a negative outcome for the Board of Adjustment members, individually or as a group? In other words, how can we get in trouble?
You guys can only get in trouble if you intentionally do something wrong. So they say, have you made up your mind? And if you tell people you made up your mind and you say no, and they somehow are able to prove that you absolutely had made up your mind and that you absolutely said it, I mean, that's not like, it's not perjury, but it's like perjury. And so that would be a problem. And obviously, things like taking money to swing the outcome, the usual kind of stuff that you hear judges getting in trouble for. But unless you guys really intentionally set out to swing this one way or another for the, but not based on the evidence, but based on other things, you can't get in trouble. You have what they call qualified.
Okay.
Sharon, this is Daniel, could you provide an example of how the board might make use of Mr. McKellar during the hearing? I mean, are they free to turn to him at any point and say, can you give us some guidance on this? Or what exactly are his boundaries?
So, when I've been at your hearings, there's lots of times procedural questions that came up. And so any kind of procedural question would be something that Judge McKellar could answer. An example of that is, sometimes you've had a question about whether you can take evidence after you close the evidence. And, I've just said you just reopen the evidence for that. And so that's the kind of question that you'll pose to him.
Other maybe practical question, can we put limits on the time that people speak?
So all of that is a share. And it is a dangerous proposition. The answer is yes, can. The better way to think about it, I think, and to phrase it, is to say that you're not going to allow repetitive evidence. So if the other thing is, got to remember this being quasi-judicial, it's not proper for you to hear everybody's opinion. It just needs to be facts. They need to be testifying about things they observed, or things that they heard, or what they see. But in terms of what somebody else is doing in another neighborhood, or what it might turn into speculation about what might happen with this, or just their opinion of what it might do, you shouldn't be hearing that. And so that I think might shorten it quite a bit if you really enforce that more. But there's nothing wrong with you, I think at the front end, telling the lawyer that you'll hear one, maybe two witnesses with the same testimony, and you're not going to allow 10 of them testify to the exact same thing. But in terms of saying this, we're only going to allow each witness to testify for X number of minutes, that's really dangerous.
Okay, and now it's, pardon me, Linda again. We will have testimony both from the applicant and his attorney, and then there will also be testimony from neighbors with their attorney directing them? Because they will be speaking there'll be people speaking either for or against the application.
There will be people giving evidence for, and that will be very much like a court case where the applicant's attorney will call witnesses.
Right.
On that. And then the people opposing it who have an interest, they've got to have some kind of an interest. They have, some portions of them have also hired a lawyer, and that lawyer will call witnesses for them.
Okay, are the people who have an interest, that namely the neighbors abutting or nearby, are they limited by a certain footage? Like people within 200 feet of something have the ability to officially complain about it? Complain being a very flexible term, as opposed to anybody in that quadrant of Mills River. Do they also have an ability to come and speak about it?
So that's gonna, in this case, Linda, the answer is they need to be adjoined.
Thank you. Directly adjoining, like it couldn't be two lots in? Because that will,
I mean, their property has to touch this property or be directly across the road from this property.
okay, because that should help
There
to,
is an issue that the lawyers will need to resolve, I was thinking, where, because the applicant owns two pieces of property. And for purposes of notice, everybody adjoining either one of those has been given notice, because that was just, there's no harm in doing that. That was the safest thing to do. But in terms of deciding who is a party and
Mhm.
evidence, they're gonna need to resolve for you at the beginning of the hearing whether one or both of those pieces of property is involved, because there's several people who only adjoin one of them.
okay, thank you.
Sharon, this is Heidi. As being new to the board and at the hearing, I'll forget everything that I already knew about this case. But my first general question is there anything that we can or cannot mandate an applicant to do when they ask?
You mean as a condition?
Correct, as a condition. Is there anything that either legally or whatever, is there limitations, or we can say whatever we want?
You can, so as a practical matter, it's really very broad what you can mandate, because what's usually done is without, and you don't have to have their consent to anything, but I'm just saying, sometimes there are big conditions attached that are not really related to the use or to that particular property. It's just been more of a general matter, and those are the kind of things which, if somebody challenged you, the court would know it's not a code.
Okay, that was, I just wanted to know, both for this instance as well as just generally when we hear things as to what we can really impose. Now, this is directly related to the applicant that I'll forget next month. He was very vague and really had no plan. If the same was to happen, and every question that we asked, he kind of changed his answer, are we allowed to not, like, tell the applicant that they have to come back with more defined reasons or answers? I mean, when we would ask him things like, how many people, how big? In one answer, he'd say one thing. In the next answer, he would totally go against what he said in the first answer.
So in that situation, you have a couple of options. You can just decide to disregard all that testimony, which means the applicant could prove their case. You can just find them to not be credible because of their, vacillation.
Okay.
Your other option would be, to make a decision instead, not instead, but to not disregard the testimony, but give it the weight that was served, and just find that they didn't prove their case because of the quality of their evidence.
Okay, could I piggyback a question in on you, Heidi? This goes back to the beginning that we are to come in here with a blank slate as far as our brain goes, and other than what is said in the application. That being said, we issued a conditional usage with certain restrictions back in whenever it was. And that was what was supposedly going to be. Now, I'm sure part of it is the neighbors are unhappy. And let's say we said the noise was supposed to stop at 11. When a neighbor begins to give testimony and they say, well, they had this event on April 10th and the noise went on until 2 a.m. and we understand that's against what you all said they could do. Can they testify to that since we're not supposed to think about anything from that initial hearing? Am I making my question understandable?
You're absolutely crystal clear. And
Good.
so the right to have start with a clean slate, in this case, belongs to the people opposing, that you ruled for the applicant last time.
Right.
So if somebody who's opposing it wants to basically waive their right, then that's something you can consider because, in court, you have a really fancy term for that called opening the door. So they've opened the door in that case.
But if they say, we heard this noise at 2 a.m. and we understand that Mr. X had an agreement that it would stop at 11, and we're not supposed to remember that that's what we did, how do we deal with it?
They told you that that's what you did, so then you can consider what you did.
Ah, okay. Along those same lines, is it conceivable that the first usage that we granted them would simply be upheld? I mean, we can't uphold the agreement that we're not supposed to talk about.
So you don't have an option of just upholding.
Okay.
You can have an option of doing the exact same thing if it were a new.
But we just have to repeat it, or conceivably, we could tweak it.
Yes,
Got it. Thank you.
you're welcome.
And maybe I'm wrong on this, but sewer, or whoever, at least the two hearings that I remember, we have those questions that we have to answer. Can we address that because they completely confuse me? I really don't know that
Are you talking about the
The proof questions?
I think
Oh, funny,
you're always
fast.
good at making the sentence, but I don't know that I really, they're kind of wordy, so I don't know
Yeah.
that I really understand them, so maybe if we can. Oh, sorry.
Are those in that script that you have? Or are they,
They are not.
okay. Let me go grab a copy of those so we can talk about it. Give me one moment.
Thanks. Sharon, I'm not sure if you heard the question and we're getting a copy of this, but.
I have them here from,
We were
here.
talking about, Heidi's question had to do with
here's the whole thing from
the findings of
February.
fact that go with the conditional use permit and how they make their motions that support or don't support them. But Daniel's going to read those. Hang on.
So for conditional use permits, the board must find the following. 1, the use as proposed will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed use. And number 2, will not be detrimental to the public welfare or injurious to to property or public improvements in the neighborhood. So I think if I remember correctly, there were questions about what exactly do those mean and how do we answer them? And then At the last hearing we had in February, if I remember correctly, there was some confusion about, since they didn't answer one of them. Do you remember that conversation we had about affirmative versus not?
Yes, the last thing we heard, it was a question of if they say no to one of the findings of facts, do they continue to vote on all of them? And Sharon, that was something you could clarify for us. If they're voting on each one individually.
Those are findings of fact, and both the state statute and your ordinance require that you find all of those. So once you can't find any of them, so once you vote no on one of them, then
So you don't have to continue to vote. It's just, we're done.
exactly right.
Okay.
That is the case, but one person can vote against one of the conditions, while you have 4 others that vote in favor. Then the process still continues, and the person that voted against does not disqualify himself for further voting, correct?
That's right, yes, that's right.
If one person votes against, and you say you have 5 people and one's voting against it, that motion passes. So you go forward. Even though the one person voted against it, because they may agree with something else.
Yeah, so you could, if there's 2 of these conditions, you vote 5 out of 5 in favor. The next one, you vote 4 out of 5 in favor. The person that voted against that second condition still can vote in favor of the total conditional use permit.
Yes.
Yes,
Okay.
yes.
Okay.
Mr. Edwards, have we completely confused you?
It gets better. We're going to have the same board members rehearing that heard in September, or is it just going to be anybody?
No, you will not have the same board members because Brandon was not at that meeting and Mr. Edwards was not at that meeting. But Sarah still has a conflict.
But Mr. Edwards and Mr. McGaha can sit on the board
Yes,
for the hearing.
yes.
Okay.
Yeah, it is basically what we've had is wiped out. It doesn't exist. We cannot refer to it. We cannot talk about the previous hearing that we had or any argument that we heard. That's not part of our hearing.
Right.
So new, doesn't matter if it's new or existing board members. It's whoever's on the board for that hearing. That's it.
That's right.
Hey, this is Brandon. Can I ask you a question real quick?
Sure.
So one thing I see that is a little different, we're talking about a quasi judicial board, is that, in a court, you're considering evidence of things that have already taken place. Kind of what sometimes we have to do is people come in and they kind of talk about how if we approve something, how it would affect the quality of life in the future. And they talk about, what will be affected and how it would be affected as far as them using their property and stuff. So how do we weigh that evidence? Do we just take into account if it's feasible that if we approve a certain thing, it could affect their property that way? I mean, what type of weight do we give their speculation on how their property may be affected?
So,
And that makes sense. Thank you.
Sharon, it's Heidi again. Do you have to have I mean, obviously, like you just said, none of us are attorneys. So if for whatever reason, sitting on the board, you think, nope, I think this is a bad idea and it shouldn't be in a residential neighborhood. Is that good enough? Do we have to have another reason, or do we have to because they put in for this change, for the change of use, right? That's what they're doing. Conditional use. And you just decide, no, don't think it's a good idea.
You don't think it's a good idea?
I mean, we're sitting here and you think, I don't believe that belongs in a residential area, and I disagree or don't feel that with any conditions, that's what it should be, and vote no. Do I have to have my reasoning based on anything other than that?
Yeah, it needs to be based on something, maybe it's just a nomenclature, but it needs to be based. The problem is that the law is written that the applicant is entitled to the permit if it proves whatever your requirements in your ordinance are. So I mean, you do not have the liberty to believe that they satisfy all those questions that we just talked about, and whatever the particular special or conditional use requires. And it is a use that is contemplated, and the ordinance gives them, the ability to use that property that way as a conditional use in that district. Then you were supposed to issue a permit. You don't have discretion. You're talking about having discretion to just say, nah, I don't think so, and you don't have that ability.
Okay.
Let me follow up on that question, because when we go through these conditions, if I vote against a motion that Linda makes, do I have to give a reason why I vote against the use as proposed will not adversely affect the health and safety of the persons, blah, blah, blah? Can I just say no?
Just vote no.
Okay.
You're not prohibited from giving a reason if you want to explain, but you don't have to.
Okay, so that's, I think the point that Heidi tried to make is if, I'm in favor of this conditional use permit, and, we get a motion, I get a second, and Heidi thinks, I think it's a bad idea. I think it's not really promoting the health and safety, blah, blah, blah. So I vote no. She's free to do that.
If right, and the danger area is that she voted for all the findings of fact, and that she voted yes for all those, and she voted no for the permit, that's kind of a red flag. But if she voted against any of the findings of fact, then she's absolutely free to vote against issuing the permit.
Sharon, I want to clarify something. We have always, when they're voting on a finding of fact, we've always asked whoever makes the motion to state a reason, that it's will not adversely affect the health or safety of persons residing or working in the neighborhood because of such and such. And you're saying that's not necessary, that we're asking too much of them.
I think that the person making the motion is one, and I think that's a good process.
Okay.
It's not required. You're right, it's not necessary, but it's good practice, and I think that's what they teach people at the school of government. I'm saying that someone who votes against it does not have to give a reason why they're voting against it.
Okay. I'm glad.
Oh, come on. Along the same lines, if they voted that the finding of facts did thus and such, then if they vote against the motion, is that the red flag you're talking about? I make a motion and I say that I move that it does not adversely affect the neighborhood because of the fact that blah, 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 that we put this in. And then it all goes through and she says, yeah, that's okay. They did their point. But then when we go to vote to give the conditional usage permit and she votes no, even though to begin with, if I was understanding you, she was comfortable with what they presented. I don't think I'm making the question right,
Okay.
but
So there's findings of fact that are required.
right.
That's what you talked about. And I don't remember how it's stated, if it's in a positive or negative, but that it does not adversely affect the health, safety, welfare of others. So that's just one of them. And so if somebody votes yes for that, if they vote no about finding another one, then I think they're free to vote against the permit. Because what the statute said, what the ordinance says is you have to find all of those. So if they believe that the applicant has not proven enough to make one of those findings a fact, then that is a perfectly reasonable basis to vote against issuing the permit. The problem is if you voted for finding all of those, the court cases say if they prove all of those to the board, they're entitled to the permit. So if somebody has voted for finding all of those and then votes no, it at least gives the appearance that that vote is not for a valid reason.
So if someone is uncomfortable with the manner of how the application has been presented, when we get into the motions from the get-go, that particular person has probably decided they really don't want them to do it. So they should also not be saying, okay, they made their point. Because if they're saying they made their point, then they're eventually going to have to say, give them their conditional usage. Yeah, true. But if they do make their point, then you have to accept it. I mean, we're not here to recreate something. We are here to keep an open mind and listen to these people. This is democracy at its best, as far as I'm concerned. And everyone deserves their day of making their presentation. And if I have voted for things that I personally really didn't want to vote for, but the person asking for it gave a reasonable explanation of why he or she wanted to do it. And I've been on this board a long time. I didn't have all this hair when I started. And so I just need to know, I want to be fair. And that's what I think every single person in this room wants. And we need to know how to do it in a legal manner. I guess that's where even Heidi's coming from. I'm off. Thank you.
You're welcome.
Any other wise words for this board?
I have no wisdom. But I mean, I guess what I want to say is that I don't want you believing that you have something to make up for in this, that you've done anything wrong, because you haven't. I mean, the process didn't work for a variety of reasons, not the least of which was Zoom, which failed us again tonight. But you know, you guys just need to feel very confident because some of you have been on there for a while and have done a fabulous job every time I've had an opportunity to be there. And I know it's poor, and I know you feel like you're having to come in and speak Martian a lot of times because it's just so different from how the real world is. But you know, and that's I know that's uncomfortable, but that's just process. And so if you can just kind of, you know, let the process play over things, just listen to the facts. I think that's always true, but I think in this particular hearing, it'll make it a lot easier.
Well, that's what we like, easy. Now, I think that we have a very good composed board with the right motivation for, you know, basically the benefit of the people living in Mills River. And I'm convinced that we're going to go into this new hearing with that same mindset. And I you know, yeah, I have full confidence, and that's what we're going to start with, and then we'll see where we end up.
So you have two very seasoned, very combative lawyers here in front of you. And the last thing that I want to tell you is that you need to let them know from the get-go that you're in charge of that hearing, and they're not. Because the worst quasi-judicial hearings I've ever had to sit through were where the board chair just didn't want to offend the lawyer and tell him to shut up.
I gladly do that.
Okay.
I have seen board chairs do that. It is effective.
There's absolutely not doing that.
Okay, well, that's good to know, and if I don't feel good, you can take it. Any other, sorry.
Don't be shy about stopping and asking Max questions.
Yeah, that's good advice.
And Matt might not be as prone as I would be to interrupt him. I mean, I don't think I've ever had to do it in Mills River, but in some other hearings, I've just interrupted a lawyer saying, basically said, you know better than that, and I instruct my client, the chairman of this board, telling you that you're not going to do that in this hearing. And so Matt won't do that, and I can't do that. But I basically think I'm going to make sure I can let Matt know that, you know, that's not going to send any ambiguity to step in and make him behave.
Okay. Any other questions right now?
We're still on for the 18th?
We are scheduled for the 18th.
Okay.
We may only have 4 board members that night. And if that is the way this plays out, then it will be up to the applicant to choose. But we did a lot of scheduling and rescheduling and round and round and round with the attorneys. This is a date we all chose. So worst case, We all show up. The applicant wants to put it off. And we've got them all in one room with their calendars.
Okay,
But that's what your process is. I mean, that's not nothing new for this. That's because you always do that, right?
Oh, absolutely. That is absolutely what we do. We show up, we see how many are here. If we're short somebody, we give the applicant the opportunity. Do they want to go forward or not? That's actually what happened in September, and they went forward with 4 board members. So, no, that is our normal process.
This is May 18th, right? Same time, 7, same station, same bat time, same bat station. Okay.
And as I understand it, you're out of town, so,
Yeah, I think I'm coming back. I don't know whether I'll be back at 7 or not. That's why.
all right. Well, if you can make it, you can make it.
it definitely is a lot more flexibility and sort of assurance if you have a full board by members. You can still attend
Certainly.
Oh, okay. I can always do
Yeah,
that.
yes, you could, but I was under the impression you were traveling, so.
Well, I'll be in the car or something. Not on the plane. Yeah, it always is, but I'll be in the car and won't have any grandkids, so that'll be.
Oh, that'd be boring.
But again, that's up to you. If you, I'll be in touch the week before,
Okay.
and then you let me know what you want to do, and if so, we'll give you a link.
That will work.
The only difference is when you're on Zoom, you have to identify yourself when you're speaking or when you're voting, but if you've ever been on Zoom, you know that.
Yeah, I think everybody in the world's been on Zoom
Yes.
last year. Try not to.
Anything else that we have to discuss?
Not at this point, no. I think this was a productive meeting. Sharon, thank you for your time this evening.
You're welcome. I'm sorry I made it so difficult.
That's fine.
Thank you, Sharon.
We're used to it and appreciate your help.
Bye-bye.
Good night.
Motion to adjourn?
I'm
So moved.
second.
All in favor?
Aye.
Thank you very much. He was not reappointed.